Hello, my name is Deborah Carlson. I'm a staff lawyer at West Coast Environmental Law. We're a nonprofit group of environmental lawyers, and we work to identify ways to improve our laws and policies so that the environment is better protected. My work focuses on the local level, and most recently I've been looking at how communities can be sustainable and resilient in the face of a changing climate. If you'd like to know more about West Coast and the resources and analysis we've prepared, please visit our website at wcel.org. Today I've been asked to offer some thoughts about climate change risk assessments related to local water infrastructure and the possible legal implications of such assessments, if any, for local governments. I should note that the potential legal consequences would depend on the facts in any particular case, which we don't have before us, nor do we yet have any court decisions directly on these issues. That being said, it's still possible to consider some higher level principles as well as case law that looks at similar issues and explore how this might inform approaches to climate change. Now the question comes down to, I suppose, should water managers put their heads in the sand about climate change or not? Before we consider the law, let's just take a quick look at the context. First off, there's a significant amount of information available about the impact of a changing climate in BC. A good source prepared by climate scientists for different regions in BC is the website maintained by the Pacific Climate Impact Consortium at the University of Victoria. And if you just Google Plan to Adapt, that'll come up. The BC WWA has also looked already at some of the impacts of climate change on water infrastructure in BC. Some of the key challenges identified relate to sea level rise in coastal areas, reduced snowpack leading to changes in the volume and timing of surface water flows, more frequent and severe storm events, and both more floods and more droughts and more wildfires. But how do these general impacts translate into specific risks related to water infrastructure? It's important to note that there isn't yet a consensus around what a climate change risk assessment involves. There are a variety of approaches out there. Carrying out a climate change risk assessment may or may not involve engaging outside technical expertise, for example. Some governments take a bottom-up approach where they rely on existing knowledge of local hydrology and operational expertise and identify vulnerability to increased temperatures or precipitation. Another approach is to work top-down, usually with climate scientists, to develop climate scenarios for a watershed, assess the range of likely temperature and precipitation changes, and then relate this information back to impacts on water infrastructure. Whatever approach is taken, uncertainty still remains about the range of projected climate impacts and how these will translate to the local level. This suggests that assessing climate change risk will be an ongoing process. You've asked me to consider whether, by virtue of obtaining information through a climate change risk assessment, that is, through some process similar to what I've just described, a local government would now face greater exposure to liability than if it had, say, just kept its head in the sand. The most typical claims against local governments relating to infrastructure failures have been either negligence or nuisance claims. So how would the knowledge about risk to infrastructure related to climate change affect each of these types of claims? There are some other issues that would need to be considered, but let's just take a very simplified view and focus on the impact of the information obtained from a climate change risk assessment. In a negligence claim, the court is interested in whether a harmful event was a reasonably foreseeable outcome of something a defendant did or didn't do. It could be argued that if the local government carried out a climate change risk assessment and learned, for example, that as a result of increased precipitation, a drainage system was likely going to fail and cause flooding, then you would be at least partway towards a successful negligence claim against that local government if that happened and they didn't do anything. But the courts might look further than what was actually known to the local government, and they might find that it ought to have known about the increased risk due to climate change, given the increasing availability of information about climate change impacts. However, when you have a negligence claim, local governments are in a special position. If they decided as a matter of policy that they weren't going to address the risk based on social, political, or economic factors, perhaps they simply decided it would be too expensive, the local government probably could avoid liability. The second type of claim, One that is probably the most common type of claim brought successfully against local governments with respect to water infrastructure failures is a claim in nuisance. Nuisance is an unreasonable interference in the property rights of others. Local governments have quite frequently been found liable when their drainage systems fail and cause flooding and property damage as nuisance claims. While statutory immunity protects local governments in BC from liability in the case of breakdowns or malfunctions, the BC Court of Appeal has found that this immunity does not apply where a drainage system fails simply because it cannot handle the volume of water flowing through it. Generally, nuisance doesn't require proving that a defendant was negligent, and it doesn't appear that a local government would be protected from claims in nuisance by keeping its head in the sand about possible risks. These are only two illustrations of the types of legal liability that local governments may face due to climate change-related failures of infrastructure. From this very high-level analysis, it doesn't appear that refusing to investigate risks related to climate change will provide significant benefits in terms of avoiding liability. In fact, it seems that being blind to climate change risks may prevent a local government from putting in place policies that could help reduce exposure related to actual events. Damages in flooding cases can amount to tens or even hundreds of millions of dollars, as class action lawsuits in Ontario have shown. Failing to address infrastructure issues in a timely manner may save money in the short term, but could result in more costly failures down the road, short-term gain for long-term pain. Local governments that ignore climate change risks may also face higher insurance costs. Not understanding the impacts of climate change on infrastructure may also mean that local governments miss opportunities to upgrade when making decisions about new and replacement infrastructure, and also that they undervalue the resilience and increased capacity offered by green infrastructure measures. Before closing, I just wanted to give you a reminder that this is general information only. For information relevant to specific circumstances, you should consult a lawyer. Thank you.